Good morning. The next matter to come before us this morning is Guy Templeton Sr. versus the Fred W. Albrecht Grocery Store Company. Both sides will have 15 minutes to present oral argument today. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Good morning, Your Honor. John Myers for the appellant. I'd like to reserve 5 minutes for rebuttal. The facts of this matter pretty much aren't in dispute. Mr. Templeton was employed by App.No. He had a workers' comp claim. He was trying to get, in addition to a pending claim, he was sent for a psychological evaluation. The doctor performed that, sends it to App.No. App.No., in part of their processing, intended to send it on to their attorney. Instead, they sent it off to a number of employees. A certain number of those employees didn't open the email. Certain employees did. At that point...
Do you mind if I interrupt?
No, I would prefer you interrupt since you've read the brief, so don't not reiterate.
It's your claim that the individual who hit the key that sent this to the 47 people that should not have received it, did it with any purpose or knowingly misdirected the email?
There's no evidence in the record to that effect, Your Honor, and I wouldn't go so far as to do that. I think we can look at this as a mistake.
Then we're both on the same mistake page. What is it about this mistake that sets it aside and suggests that there was sufficient intent for the underlying tort?
Well, with regard to the claim under Biddle, there doesn't need to be that requisite intent.
So what is needed?
Unauthorized disclosure, period.
So strict liability.
The courts haven't gone that far,
Okay.
but I believe if you read Biddle, it's unauthorized disclosure, so you can, this court could hold that it's strict liability. If you look at the supplemental authority that I filed this morning, that was a case of the Ohio prison system. The plaintiff in that case was HIV positive, an inmate. The inmate's information about the HIV was left on a desk in the infirmary. In that case, another inmate who was a porter, who was in the infirmary as part of the duties that were assigned, saw that. Saw the name and the HIV positive, and then spoke to other inmates about it. In that situation, the court looked at it as an inadvertent disclosure, but still found liability on the part of the state because the state had a duty to maintain confidentiality of medical records, even in the prison setting. The same would hold true here. App.No. has a duty as part of the workers' comp system to maintain those medical records of employees in a confidential manner. The same would hold true if there was an FMLA claim and medical information was submitted. Any medical records in the possession of an employer have to be maintained in confidentiality. And the minute that those are released, that the tort is committed. You cannot unring that bell. Then it becomes an issue of damages.
Well, so then you're agreeing that my question is whether it's strict liability. You're saying yes, you did.
I would go so far as to say it's strict liability. Mainly because of the nature of the records. In Biddle, the Supreme Court recognized that medical records are confidential. Period. End of story. In this situation, App.No. had no release from Mr. Templeton that said you can send those records to third parties other than people that are involved in the workers' comp system. Absent that, there was no other duty or privilege that App.No. had to disclose those records. And unless courts recognized that absolute duty on the part of an employer or anyone who's entrusted with medical records of an individual, you get into the game.
But the cases in this don't use that terminology of strict liability, do they?
They dance around it, Your Honor.
So you're asking us to this is a case of first impression, in your opinion?
Yes, because if you look at the cases that I've cited, Biddle and Hageman. Hageman extended Biddle to an attorney that used medical records that was authorized release for one proceeding, used them in another proceeding. The use of them in the second proceeding constituted a tort. If you look at the...
But that wasn't done, that was not done accidentally. It was done intentionally. The decision was made to use it in the other case. And so does that not distinguish the facts of that case from the less intentional, accidental conduct of the App.No employee in this case?
No, because we still get into the slippery slope of what's the necessity for the intent. The fact that the tort occurred upon the disclosure. If you look at the Herman v. Kroschke case, that was a situation where a doctor examined an individual, thought that individual was pursuing a workers' comp claim, and forwarded those records to the employer. The minute those records are disclosed in that situation, the tort is committed.
But that person didn't do it accidentally. That person did it intentionally.
But it was inadvertent.
Well, no, it wasn't inadvertent if they intended to send it on to the recipient that they chose.
But if you attribute some intent, why do you need to attribute intent?
Well, it just seems to me that this is all about intent because of the case law and the claim, intentional tort.
Well, the Biddle claim is not an intentional tort, Your Honor. If we're looking at the invasion of privacy
Well, isn't
claim,
that a tort?
it's a tort.
Okay.
And you can see,
have to have an intent for a tort.
well, they taught us in law school.
All right. So again, my question is, what kind of intent are we talking about here?
I think you go with the strict liability, at a minimum go the negligent intent, negligence. Here, clearly there was some negligence on the part of App.No.
Well, your brief references negligence or recklessness. Does it make a difference?
That's with regard to the invasion of privacy claim as opposed to the Biddle claim. But the invasion of privacy claim, if you look at, it's generally recognized for...
I can't seem to turn this off.
That wasn't mine, Ron.
I've tried.
If you look at, but in the invasion of privacy, it's generally recognized that there has to be some intent. But the case law in Ohio is very unclear. It could be a reckless disclosure or a negligent disclosure for an invasion of privacy claim. The Biddle claims that's a separate tort apart from an invasion of privacy. And as I see it, the minute that individual or entity that has the medical records and is obligated to hold them in confidence, the minute it's released, that's the tort right there. We can fight about intent, but the fact it's the release, whether it's intentional or negligent, or strict, if you apply a strict liability standard, that release constitutes the event.
And remind me, was this case was resolved on summary judgment?
Correct.
Okay, so the issue is whether there is a genuine
Right,
issue of fact.
and if you look at the case law, with regard to a Biddle claim, there is an issue of fact here. The fact of the matter is that it got released, so I don't think that it was up to the trial court to make that determination. That was a jury question. I think if you look from that standpoint, Your Honor, the court did step in to the shoes of the jury in that instance. There would have been an argument as to what the appropriate charge would have been to a jury as to whether it was what level of intent. Should it be strict liability? Should it be negligent? Should it be reckless? Those were issues for the trial court to resolve in the full litigation process as opposed to its summary judgment. The court has no further questions. I'll take my seat.
May it please the court. My name is Alex Frondorf. I represent the appellee, the Fred Albrecht grocery store, also known as App.No Fresh Market. As you've just heard from the appellant this morning, this case is all about intent. And as you've also heard from the appellant, he has acknowledged that the email that is central to this case was sent mistakenly. It was inadvertent. It was an accident. Every day, we all send dozens of emails. Around the world, billions of emails are sent. From time to time, a mistake is made and an email is inadvertently sent to the wrong recipient. That is what happened here. And back in March 2012, now 3.5 years later, 3.5 years ago, when that email was sent, the appellee took immediate corrective action. That very day, following up with the next day, they were able to recall 27 of the 47 emails, leaving only 20 out there.
Excuse me for interrupting, but does that go to damages or to the foundation of the claim?
Well, there's an invasion of privacy claim, and one of the elements of invasion of privacy is publicity.
Right. And there were, what, 20-some that were not recalled?
That were not immediately recalled.
Right.
Sure.
And what is your position? Is that who has the burden of showing what happened to those 20? Don't we presume that they were received and read? What's in the record on that?
But we need not make any presumptions because the record reflects that many of the people did not read them. They may have been open, realized it was not intended for them, and closed it. Acme met with each of the 20 people who they were not immediately able to recall and made assurances that the email was, one, deleted, and that they did not read it, and if they had, that information remained confidential.
Okay, thank you.
And they are also able to determine through their IT department that not a single one of those emails was ever forwarded. And the case law requires for publicity that the email would have been substantially certain to become one of public knowledge.
Wasn't there one individual who indicated that he or she printed the email? I thought I read that in the brief.
Understand
Or
it.
read it?
They,
Somehow reproduced
that may
it.
have been the case, Your Honor, and then it was made sure that that was deleted and that had been removed from their possession. So all of the emails were in their possession, or that were removed from them.
So 20 people is not public knowledge as it relates to a medical record? I mean, I'm trying to find where the parameters of that publication element would be.
Okay. So if we look at the case Roberts versus Hagan, and then that was decided by this court in 2000, and then a subsequent case, Rowe versus Heap, decided by the 10th District in 2004, they looked and interpreted Roberts and said, in determining whether appellee's emails were public disclosures, the character of the communication and the likelihood that they would become public knowledge wield more persuasive force than the number of persons to whom the disclosures were initially made. So if we look at the character, it was sent internally, internal company, and so that was not a public disclosure. And an immediate corrective action was taken, and I do mean immediate, that very day, and the following day, which was a Saturday, to ensure that that information went no further. And in fact, as we stand here more than 3.5 years after the fact, there is nothing in the record to suggest that any adverse action ever resulted from that inadvertent email. No adverse employment action. There was never anything that the appellant heard discussed. There was no financial damages. And to this very day, the appellant remains a valued employee of the appellate.
Why should we conclude that just because the other 20 were also employees of Acme, that they cannot be characterized as public for the purpose of disclosures?
In the case, so if we look at the, I believe it was Killian, I'm sorry, it was Rowe, where an inadvertent email was sent out to United States diving officials, and the exact number was not given. The court said that it was a handful, was the language that they used. And there, because it was internal to the U.S. diving officials, it did not go to the public, that they characterized that as less likely to become certain to become one of public knowledge. And so because it was a private email, it was not sent out to the world, it was not made public to anyone who wished to have access to it, it was only sent to the first and second cashiers. The vast majority were immediately recalled. Of those who were not immediately recalled, they were deleted, and assurances were made that not a single one was ever forwarded. But even if you get hung up on the publicity element of the invasion of privacy claim, the invasion of privacy also requires intent. And Your Honor, that is what you were getting at just a brief moment ago with the appellant. Every court to have considered the question of intent in the invasion of privacy context head on has required a finding of intent. Everything from every case, both state and federal, in the state of Ohio since the 1950s, whether it's McCormick versus Haley, Sekar versus Rakestraw, Deritos versus Abbott Laboratories, these are all cases cited in our brief. They all required a showing of intent.
Well,
The
how
cases-
about the issue that's raised in the appellant's brief, that the name of the individual, of the attorney to whom the privileged information was intended to be sent, is very different from the listserv of the cashiers. And what particularly in light of the posture that this case is presented on summary judgment, that any inferences are required to be construed in favor of the non-moving party.
So I heard two questions there. I'll start with the one with the posture of the case as being summary judgment. Plaintiff, the appellant, was fully able to develop the record and had an opportunity to do so, as did the defendant, the appellee. And no evidence, zero, was introduced into the record suggesting any intent or any reason or any motive for Ms. Seymour, who's the individual who hit the send button, to have sent that email. In fact, there is evidence in the record to suggest that they barely knew one another, that they had met only one or two times in his nearly 30 years of employment, over 30 years of employment at Acme.
Except that it wasn't the appellant's burden on summary judgment. It was the appellee's burden, the store's burden, to demonstrate that there was a lack of any
Issue of material fact. Yes, Your Honor. And what the court looked at was the record before them, and they had the affidavit of Mrs. Seymour, they had the testimony of the plaintiff, the appellant, and there was nothing in the record that would allow the court or a reasonable jury to find or even infer intent. There was simply an absence of any, a complete lack of any evidence. And so the court granted summary judgment on that one.
So can lack of care and attention to a keyboard key, a stroke, you're saying that that is insufficient to
Your Honor, I believe that,
support the intent that is required for the tort?
correct. I believe that that would support a finding of negligence, but I do not believe it would find...
Even though it requires an intent to physically hit a key. So we're talking intent on a different spectrum.
Correct. So the volitional act here is the clicking of the mouse button.
And that's all you say is necessary for the tort?
No, I'm saying that because she intended, her mind, and the email that was drafted reads, it was intended to go to the attorney, Mr. Davies, please review, I will hold off sending to the Industrial Commission and his attorney until Monday in case there are issues that need to be addressed. The body of the email evidences intent. This was intended for the attorney. There's no good, to go back to your question, Your Honor, there's no good explanation for how the first and second cashier ended up there. And it was an inadvertent mistake and an inadvertent keystroke. And then when she hit the mouse button, hit send, that was a mistake. That was an error, but it was negligence. It was not intent. It was not willful.
Well, I guess the issue there is whether or not a jury should be entitled to make that determination from all the circumstances.
There's again nothing in the record, and even the plaintiff's own testimony was on page 119 of the transcript, which is in the record before you. When asked, he has no evidence whatsoever to give a reason as to why Ms. Seymour would have sent that email. There's no intent. There's no motive, in other words. So there was nothing there to allow a jury to even infer intent. There's nothing for them to hang their hat on, so to speak. If I may move on to the breach of confidential information. claim, which is what the appellant spent the bulk of his time arguing, there too we look at intent. And in both Biddle and Hagman, the Ohio Supreme Court found that intent to be an essential and dispositive element of the claim for breach of confidential information. The Biddle court required that the defendant be proved to intended to induce that the records be given to an unrelated third party. In Biddle, it was a hospital. In Hagman, it was an attorney who had received medical information pursuant to one piece of litigation and then turned it over to for involvement in a second, in this case, a criminal part of the litigation. And the court found that both of those intentional acts of turning over that medical information breached a duty of confidence. Here, those facts do not present themselves. We don't have a medical entity which is required for this cause of action as found by the Ohio Supreme Court. And even when expanded slightly in Hagman, it was limited to the attorney who had access to that medical information. Here, this was sent out by someone who worked in the Human Resources Department. And again, there is no evidence of intent. The case that appellant submitted to you moments before, less than a half an hour before this oral argument, should have been turned over on November 20th. The case was decided November 4th. He had more than adequate time. But even if this court were to consider his supplemental authority in Doe, again, there is a policy that is issued that can be found to have been either willful or negligent. Here, there is no policy. There is no affirmative action. It was a mistake, and appellant has admitted that. It is a mistake. It was an inadvertent click of the mouse button. It is more analogous to the case in Scott versus Ohio Department of Rehabilitation, or to where the medical files were shredded and it was not foreseeable that they would be pieced back together. Here, when you allow people to have access to medical files, it's foreseeable that someone may in fact access them. That's a policy that was at fault. Here, this is simply an inadvertent and mistaken email that was sent out. And every court to have considered the breach of medical confidence has required intent. Every single one of them. You would be the case, as Your Honor suggested, case of first impression, to hold otherwise. Appellant suggested that this court impose a duty of strict liability. That is found nowhere in Ohio case law. Nor is it found in Ohio case law that negligence may substitute for intent as a dispositive element of this cause of action. If Your Honors have any other questions, please.
Seeing none. Thank you.
Thank you.
If I may, Your Honor. Albrecht's argument seems somewhat callous to me. Somewhat callous to me. In this day of emails, we all inadvertently send emails. I know that I don't inadvertently send privileged communications to people who shouldn't receive them. That is a duty that I have as an attorney. The individual at App.No who processed the workers' comp claims in the HR department had a duty. Her duty was to safeguard the records, medical records. Her act of disclosing those is simply prohibited by law. If you follow Albrecht's argument, if every few hundred emails, medical records get out, that's okay, it's a mistake. At what point in time does it become critical? The courts have held that the critical moment is the time that they're released. And in this instance, it's when that button was hit. Records that were to go to an attorney who had privilege to see those medical documents wasn't on the list of recipients. It was first and second head cashiers from throughout the Albrecht/App.No chain. This wasn't all one store. This was store-wide, various locations. A record reflects that Mr. Templeton, who had worked there for some 27 years, knew a lot of these people, knew their families. It impacted him severely. And if you look at the email, the note on the email that they would have seen when they received it, the Templeton site evaluation. One of the evaluation, one recipient printed it out, put it on a desk. Another recipient perused it. That is publicity. Those individuals got that information. That email noted what the content of that email was. Even without opening it, people could see that it was Templeton psych evaluation. That should not be disclosed. The courts in Ohio, with regard to an invasion of privacy claim, have not all required intent. If you look in the appellant's brief, the courts question whether reckless or negligent conduct can constitute an invasion of privacy. The Supreme Court has not ruled on that. Let's go to the medical confidentiality claim. The courts have not required that the conduct be intentional. The Ohio Supreme Court has not said that, and the lower courts have not interpreted it as such. The Ohio Court of Claims in the Doe case looked at inadvertent disclosure and found that inadvertent disclosure can still suffice in that to support that tort. So we're not talking in absolutes. We're talking here is that this court, since this is a matter of first impression, could look at the case law and determine if there's strict liability in the Biddle type claim, or that negligence is sufficient. Again, it would be a case of first impression in this district. The Ohio Court of Claims has looked at it, and I believe in Scott, the 10th District Court of Appeals did not require intent. It's a lesser standard. And if you look at the first paragraph of the syllabus in Biddle, it says unauthorized disclosure. It doesn't say intentional unauthorized disclosure. It doesn't say negligent unauthorized disclosure. It says unauthorized disclosure. That's what the lower courts are troubled with. What does unauthorized disclosure mean? Does that mean intent? Or is it strict, if you have a duty to preserve confidentiality of a record, and you disclose it, no matter what the intent is that sufficient to support this tort for breach of confidentiality? I submit that it is. And the facts here at least get us to a jury.
Wonder what the policy considerations would be, because, when we consider a case, particularly a case of first impression, we're not just considering the case as it relates to your client, but it's all the other possibilities that may come up.
And I have a response, Your Honor. The public policy is public policy favors the confidentiality of medical records. And if you look at, Bill was decided in one context. In Hageman, the Supreme Court said, well, the facts and the cause of action from Biddle doesn't exactly apply here, but the rationale does. That's the public policy, the rationale, is the confidentiality of medical records. And I think that's where it's troublesome if you don't apply, at least look at it as a negligence standard and not a strict liability. I think anyone who has a duty to maintain the confidentiality of medical records should not be permitted to inadvertently disclose through the email process because they hit the wrong button once in a while.
And counsel, regretfully, you have utilized your entire 15 minutes of
Thank you.
argument this morning. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides, as well as posted on our website, posted on the Ohio Supreme Court website. You can link to that through our website if you wish.
Thanks, Sharon.
We're adjourned until Thursday at 7 p.m.